Hi, I'm Terry Cox, Communications Director for the California Statewide Law Enforcement Association, and with me is legal counsel Jim Vitko. And Jim, you're here to talk to us about social media because it's huge, we all use it, but we can get into trouble with it.
Absolutely, and this is rapidly becoming one of my favorite topics because it is very hot right now and there are some pitfalls. Everybody has some sort of media account. Okay, Facebook is incredibly popular. People text back and forth. They have Twitter accounts. Also, people post almost every facet of their lives online, as we well know.
We get to feeling very comfortable with Facebook and Twitter and what we say on it, don't we?
Absolutely. Sometimes we kind of forget that there is a large audience for this sort of stuff, and if you don't take some care in terms of how you protect your privacy, it might get in a position, particularly with our peace officers and others that have responsibilities to maintain an image both for themselves as a peace officer and for the department. It could get them in a position where they could conceivably hurt their career.
And when you talk about a large audience, you're talking also about your supervisor, perhaps.
Perhaps. And again, it comes down to how your settings are configured on your computer, who you invite to be part of your Facebook friends, or who is part of your family online, so to speak, and who they share it with as well. If something's out on the internet, you run a risk that it's going to be seen by anybody, including your employer. So
There's
you
nothing
need to be
private,
careful.
right? There is absolutely nothing private about anything you put on the internet.
In my experience, there's no such thing as privacy. After working for a number of years prior to my life as an attorney, working computer crimes with the Department of Justice, I can tell you that there's no such thing as privacy.
So you want to be careful about what you put on the internet, things we don't want to put on the internet, things that are going to get you in trouble with your boss or in your workplace. Absolutely.
Absolutely.
What are some examples of those things?
Well, again, for our peace officers, what we're talking about would be posts that would show you in a professional light. You have some indicia of your employment. You know, for instance, you wear a uniform, or if you have a badge, or if you decide that you are going to brandish your weapon, and along with that you make comments about who you work for. Well, that can be problematic. There is a responsibility on behalf of our peace officers to maintain a higher level, and they can be held responsible for placing their agency in a bad light.
Now, even if you're not a peace officer, you don't want to be on the computer on Facebook or Twitter making comments about your supervisor or things that go on in the workplace that are going to get you in trouble.
You probably shouldn't. However, there is some interesting legislation that came out that's kind of related to that, and there's also been some direction that's been coming from the National Labor Relations Board having to do with situations where there have been conversations that have been online having to do with employers, working conditions, and some of those things are protected. During the last legislative session, there were two laws that came up. Of importance is what was Assembly Bill 1844, which is now incorporated into Labor Code Section 980, which prohibits employers from requesting or requiring an employee or an applicant for a position to disclose his username or password, or to access their personal media in front of them for the purposes of making judgments having to do with hiring or status within the agency. There used to be a time when, particularly for peace officer backgrounds, you would be called in, and during the course of the background interview, they would ask you things like, I want your password and I want your sign-in for your social media accounts. And they would actually access that in front of you on some occasions. And then they would ask you to explain what's on there. Obviously, that could be a little bit embarrassing. And the impetus behind the legislation was that there are some things that you will post online having to do with your views on a variety of things, your sexual orientation, religious views, things like that, which are your privilege to do and are not the business of your employer. So that was kind of what the background is to that.
What happens when you're using the computer in your workplace to access social media? Does your supervisor then have a right to look at that because you've used company computers?
He can. There generally is no privacy on a work computer. And we tell people that communicate with us for legal matters using their employer's computer as well. Normally when you sign into those computers, you'll see that splash screen that comes up and it'll tell you that the computer is the property of the department and you have no privacy rights connected with that. So if you're going to be on Facebook or you're going to be on Twitter and you're going to be talking about personal issues using your state computer, it's possible that you're going to be able to get into it. The other thing is that you are now using state time for issues that are not work related. So the possibility of that becoming an issue of misconduct are there. And going back to the legislation that I just referenced, there's an exception having to do with investigations of misconduct. So even under that legislation, they're going to be able to get into it.
Now, some companies, most companies are now using social media, so some employees have to access and use social media on behalf of the company. Are there any guidelines there?
The way that I understand it is if you are using a company computer and you are acting as a representative of the company, or in the case of our members, their departments that are trying to further their mission, then they can set the requirements, they can set the rules as to what you can talk about and what you can't talk about, because you are not going out as Terry Cox as an individual, you are going out as Terry Cox as a representative of ABC company or what have you. We've had a couple of experiences in the not too recent past where we've had some departments that are coming out with social media policies, and the last one we did, it was specifically related to their website and their Facebook account, and that was perfectly acceptable.
So as these policies are being developed, if our members have any questions about them and how they pertain to them, should they give you a call?
Absolutely. My hope is that the departments are going to be running this past us as it occurs anyway. I would think that to the extent that it impacts the day-to-day working conditions of our members, they should be doing that. But in the event that they don't, members should contact us. We need to take a close look at that. As I said, the law is evolving in this area, and I expect there's going to be considerable litigation before it's pretty much said and done. But based on the opinions that we've seen from the National Labor Relations Board, which has kind of taken the lead on this, employees have every right to discuss workplace issues online, provided that they are doing it with other employees. Okay, it's what you call protected concerted activity. They have the right to discuss working conditions. They have the right to talk about supervisors as it affects the day-to-day operation and their working conditions. Where the NLRB was critical was in activities that were not concerted, where if I just start publishing negative things about my employer, slanderous things about a particular employer, without involving other employees, just simply posting things because I'm unhappy. They were also concerned with things that might involve issues like sexual harassment, violence in the workplace. If you get on and you threaten your supervisor, that is not protected. This is becoming more and more topical these days, and I would expect that more and more employers are going to start bringing policies forward, and they're going to start attempting discipline based on some of the things that turn up on these web pages. So we need to be careful about obviously things that are vulgar, things that are hostile, things that are obviously improper. But you do also have the right to talk.
All right, thank you, Jim. Jim is one of 3 attorneys from our Southern California office. We also have 3 in our office in Northern California. We invite you to email us or give us a call because we are here for you. Thanks for your time.
Thank you very much.